Okay, so this is probably going to be another 20-minute recording. Reading from the Convisor Mini Review, Constitutional Law. I legitimately am in part 3 of the outline, State Regulation or Taxation of Commerce. Part 8, Regulation of Foreign Commerce. With a few minor exceptions, the power to regulate foreign commerce lies exclusively with Congress. Part 9, Regulation of Interstate Commerce. Regulation of Commerce by Congress. Power of Congress to supersede or preempt state regulation. When Congress regulates interstate commerce, conflicting state laws are superseded, and even non-conflicting state or local laws in the same field may be preempted. Power of Congress to permit or prohibit state regulation. Congress may permit state regulation that would otherwise violate the Commerce Clause. Likewise, Congress may prohibit state regulation that could otherwise be upheld under the Commerce Clause. Congress may not, however, permit states to violate civil liberties. State regulation in commerce. Of commerce in the absence of congressional action. If Congress has not enacted laws regarding the subject, a state or local government may regulate local aspects of interstate commerce. To do so, however, it must not discriminate against or unduly burden interstate commerce. If it does, the state and local regulation will violate the Commerce Clause. Examiners sometimes use the terms dormant Commerce Clause and negative Commerce Clause. These are merely descriptive terms that reflect the above idea, even where Congress has not acted. The Commerce Clause restricts state regulation of interstate commerce. States may not favor local economic interests or unduly burden interstate commerce. Discriminatory regulations. State or local regulations that discriminate against interstate commerce to protect local economic interests are always invalid. Example, New York cannot ban California wines or tax them at a higher rate than local wines. Exception, important state interest. A discriminatory state or local law may be valid if it furthers an important non-economic state interest and there is no reasonable non-discriminatory alternatives available. Example, a state could prohibit importation of live bait fish because parasites could have a detrimental effect on its own fish population. However, a state could not prohibit export of live bait fish when no major state interest is involved. Exception, state as market participant. A state may prefer its own citizens when acting as a market participant, which is when buying or selling, hiring labor, or giving subsidies. Favoring government performing traditional government functions. The Supreme Court applies a more lenient standard when a law favors government action that involves the performance of a traditional government function such as waste disposal. Discrimination against interstate commerce in such a case is permissible because it is likely motivated by legitimate objectives rather than by economic protectionism. State regulation of interstate commerce. This is a chart on page 19. It's like a flow chart. It's a decision tree. Does the state regulation affect an activity addressed by federal legislation? If yes, then invalid state regulation if federal law preempts the field or the state law conflicts with the federal law. Valid state regulation if the federal law authorizes the state law. If no, the first question actually was answered in the negative. The state regulation affects an activity addressed by federal legislation. If the answer is no, then the next question is, does the state regulation discriminate against interstate commerce? The answer is yes. It's invalid. There's 3 criteria on here. And what exactly are they? It furthers an important non-economic state interest, and there is no reasonable non-discriminatory alternatives. 2, the state is acting as a market participant. Or 3, it involves government action regarding the performance of a traditional government function. The answer was no to whether the state regulation discriminates against interstate commerce. Then the next question in this sequence is, does the state reputation burden interstate commerce? If yes, invalid unless the state's interest in the regulation outweighs the burden on interstate commerce. If the answer to that was no, then it's a valid state regulation. Of course, Congress has no power to authorize legislation that would violate other constitutional provisions, such as the Privileges and Immunities Clause of Article 4. All right, next page outside of this. Oh, there's another chart, and this is the Commerce Clause versus the Article 4 Privileges and Immunities. Remember that discriminatory laws may also violate the Privileges and Immunities Clause of Article 4, see chart below, or the Equal Protection Clause. So in this chart, on the left-hand side, you've got states and local action discriminates against out-of-state entities, and then you see how that's handled in commerce and privileges and immunities. The next kind of subsection, there's another 3 subsections, which we'll talk about. So for the first one, when the state and the local action discriminates against out-of-state entities, the Commerce Clause, if discrimination burdens interstate commerce and there is no applicable federal legislation, the action is invalid unless, Romanet 1, it furthers an important non-economic state interest and there are no reasonable non-discriminatory alternatives. 2, the state is a market participant, a purchaser, seller, subsidizer. Or 3, it involves government action regarding the performance of a traditional government function. I actually don't have a note card for this, so I absolutely need to make one. Because that's a grand analysis right there. I mean, really, if it burdens interstate, if the state or local action discriminates against out-of-state entities and burdens interstate commerce, and there is no applicable federal legislation, the action is invalid unless these 3 exceptions. 1, versus the standard, that it furthers an important non-economic state interest and there is no reasonable non-discriminatory alternative. Market participant exception, purchaser, seller, subsidizer, or the government action involved is the performance of a traditional government function. So how is this handled in the Privileges and Immunities Clause? Like by contrast, and again, this is the same thing. This is the state local action discriminates against out-of-state entities. What happens with Privileges and Immunities of Article 4, the action denies the out-of-state person an important economic interest such as livelihood or civil liberties, and the discrimination is intentionally protectionist in nature. The law is invalid unless the state has substantial justification and there is no less restrictive means. Now, when you're reviewing state and local action that does not discriminate under the Commerce Clause, if the law burdens interstate commerce and the burden outweighs the state's interest in the action, the law is invalid. So it can't just be arbitrary, right? Not arbitrary. I don't think I have a pen. But under the Privileges and Immunities Clause of Article 4, Privileges and Immunities Clause does not apply where there is no discrimination. So may an alien or a corporation be a plaintiff? Under the Commerce Clause, it's yes. And there's also a market exception, a market participant exception, yes and yes. However, Privileges and Immunities Clause of Article 4, no, an alien or corporation may not be a plaintiff, and there is no market participant exception. Note, the Article 4 Privileges and Immunities Clause is stronger than the Commerce Clause, no market participant exception, but it is much narrower in scope, applies only to discrimination against economic interests or civil liberties, does not protect corporations or aliens. So here's these, containers I was talking about in earlier readings, the economic interests or civil liberties. Move on to the non-discriminatory laws balancing test. If a non-discriminatory state law, for example, a law that treats local and out-of-state interests alike, burdens interstate commerce, it will be valid unless the burden outweighs the promotion of a legitimate local interest. The court will consider whether less restrictive alternatives are available. For example, an Iowa statute banning trucks over 60 feet was invalid because states showed no significant evidence of increased safety and the burden on commerce was substantial. State control of corporations. A different standard may apply to statutes adopted by the state of a corporation regulating the internal governance of a corporation. Because the state's long history of regulating the interstate governance of corporations that they create, and because of their strong interest in doing so, even a statute that heavily impacts interstate commerce may be upheld. For example, a state may deny voting rights to persons who acquire a controlling interest in a state corporation without approval from other shareholders, despite the impact that this may have on interstate commerce. Exam tip: when a bar exam question involves a state regulation that affects the free flow of interstate commerce, you should ask, does the question refer to any federal legislation that might supersede the state regulation or preempt the field or authorize state regulation otherwise impermissible? If neither of these possibilities is dispositive, does the state regulation either discriminate against interstate or out-of-state commerce or place an undue burden on the free flow of interstate commerce? If the regulation is discriminatory, it will be invalid unless it furthers an important non-economic state interest and there are no reasonable non-discriminatory alternatives and the state is a market participant. If the regulation does not discriminate but burdens interstate commerce, it will be invalid if the burden on commerce outweighs the state interest. 21st Amendment, state control over intoxicating liquor. Intrastate regulations. State governments have wide latitude over the importation of liquor and the conditions under which it is sold or used within the state. However, regulations that constitute only an economic preference for local liquor manufacturers may violate the Commerce Clause. Interstate regulation. Liquor in interstate commerce is subject to the Commerce Clause. Federal power. Congress may regulate economic transactions involving liquor, for example, sales of alcoholic beverages through the federal commerce power, for example, antitrust laws, or by conditioning grants of money, for example, highway funds given only to states with minimum drinking age of 21. So there's a Part X, power of states to tax interstate commerce. The same general...
Silver alert. Missing endangered elderly. Details at http://chp.click/alert.
Interesting. Power of states to tax interstate commerce. The same general considerations that apply to the state regulation of commerce, see supra, apply to state taxation of commerce. There's general considerations, use taxes, and sales taxes. Ad valorem, privilege, license, franchise, or occupational taxes. And power of states to tax foreign commerce. There isn't, right? The import-export clause of the Commerce Clause greatly limits the state's power to tax foreign commerce. Before we get to part 4. So I don't think I can cover all this in like 3 minutes, but let's just try. The same, okay. General considerations. Congress has complete power to authorize or forbid state taxation that affects interstate commerce. General considerations. Congress has complete power to authorize or forbid state taxation that affects interstate commerce. Discriminatory taxes. Unless authorized by Congress, state taxes that discriminate against interstate commerce, for example, tax on out-of-state businesses higher than tax on in-state businesses, violate the Commerce Clause. Note that these taxes may also violate other constitutional provisions, for example, the Privileges and Immunities Clause of Article 4 or the Equal Protections Clause. Non-discriminatory taxes. A non-discriminatory tax will be valid if the following requirements are met. Substantial nexus. To be valid, a tax must apply to the activity having a substantial nexus to the taxing state. A substantial nexus exists when the business avails itself of the privilege by doing business in the state. A physical presence in the state is not necessary. Fair apportionment. To be valid, the tax must be fairly apportioned according to a rational formula. However, the taxpayer has the burden of proving unfair apportionment. However, an unfairly apportioned tax may also violate equal protection. Fair relationship. To be valid, the tax must be fairly related to the services or benefits provided by the state. Use tax. Permissible and buyer state. Use taxes are imposed on goods purchased outside of the state but used within it. They are valid. State may force seller to collect use taxes. An interstate seller may be required to collect a use tax if the seller has a substantial nexus with the taxing state. Example, maintains offices in the taxing state. What else is going on? A physical presence is not required to establish a substantial nexus. I'm going to pause before state taxes and like ad valorem taxes.